Hi everyone, Harry here with a quick dispatch from the U.S. Supreme Court, which this morning issued a much anticipated decision in the Scrutiny case. Scrutiny is one of the plaintiffs that challenged a statute that Tennessee enacted that prohibits minors from receiving medical care, puberty blockers, hormone therapy, in order to effectuate a change in gender identity. You can get that treatment for other reasons. For example, they give it for delayed puberty. Adults can get that treatment in Tennessee. But Tennessee says that minors can't get it, and 3 minors and the doctor and parents immediately sued. And what they said in the Supreme Court was, the basic sort of factual backdrop is sometimes, not always, but and it's obviously a very complicated situation, but sometimes it is medically exigent for minors to get this treatment. And if they don't, and they have genuine gender dysphoria, they are consigned to a life that seems to have really, terrible risks of catastrophic outcomes, including suicide. So the position of plaintiffs is we should be able to do this sometimes if parents and the patient and doctors say so. And Tennessee wants to come in and say, no, never, ever. Now, this is laid out at much greater length in my Is It Legal Substack live from this morning. But basically what it comes down to is whether the court would apply so-called intermediate scrutiny. There are 3 levels of scrutiny: rational basis, almost anything goes; strict scrutiny, strict in theory, fatal in fact, almost nothing goes; and in general, for sex-based classifications, the court applies intermediate scrutiny, says they're often based on prejudice and stereotypes, and the state has to come in with a pretty good reason for doing it and a pretty good fit. And I think it was basically common ground here that if the court permitted the plaintiffs to get intermediate scrutiny, the statute would fall. And sort of the purpose for intermediate scrutiny, as Justice Kagan said in dissent, is to smoke out the legislator. This is the kind of case and a sex-based classification that might well be motivated by stereotype and prejudice, and intermediate scrutiny could, really make that clear. But the 6 members of the court say, no elevated scrutiny, just the lowest level, and it passes under the lowest level. And you have separate opinions, but a pretty strong set of statements basically rejecting and firmly the idea of any kind of elevated scrutiny for distinctions based on transgender status and very possibly also sexual orientation under the Equal Protection Clause. Now, there's this case that maybe right now your antenna might be buzzing in the back of your head from a few terms ago called Boto, in which the court, in an opinion by Gorsuch, said that Title VII, which bans certain employment actions based on sex and other things, is in play when people make employers say distinctions based on sexual orientation, transgender status. But first, Gorsuch said not a word at argument or in the opinions, of which there were 6 separate, but none by Gorsuch. And basically the court said that was Title VII. That's because of language, the Equal Protection Clause is a more overall inquiry about the reason for doing it. And we're saying that they made distinctions here based on nature of the medical treatment, because some people, you can always get it for certain things like early onset puberty, just not for other things like to change your gender identity. And adults can get it, so it's also based on age. But they discussed at great length and vehemently disclaimed that the distinction set up in SB1 is a sex-based distinction, and had it been, or had they determined it was, it would have given rise to a greater level of scrutiny and the law would have fallen. So you have separate opinions by Barrett, Ann Alito, and Thomas, and to summarize the theme of them, don't look to this Supreme Court to give equal protection status to groups that don't have it already, namely race and religion being the main two. Sex, straight out, male versus female classifications has this intermediate scrutiny, but they were not very warm to that idea, and B, went through the sort of important, most famous footnote in Supreme Court history. I won't go too deep into it on this one. If you want more info, check out the Substack. But they basically said, here's the reason why transgender status doesn't qualify. Then three dissents, the longest, two dissents, one by Kagan, one by Sotomayor. Jackson joins, and she has a very vehement, plaintive, sad. That's what she said at the end. Is she read it from the bench, which is a dramatic gesture that happens in June when certain people have lost cases, and she just said, this is really a wrong turn for the court, both in terms of, minors with gender dysphoria, but just in general in our equal protection jurisprudence. You really should have recognized we're talking about, to use that footnotes analysis, a discrete and insular minority, transgender people. Barrett, among others, had said in her opinion, not really. They're like here and there and everywhere. I don't think that's what we think of as discrete and insular. That's just a little Littman editorial aside. So are racial groups and religious groups. And then they don't have the political power to protect themselves in the normal process. That's a kind of consideration that the court has traditionally employed. And here, basically, the court, including Barrett, says, I don't know, maybe we need more evidence, etc. Kagan joined Sotomayor's dissent, saying only that we need heightened scrutiny here. I recognize it's complicated. There's different kinds of evidence on all over the place. So I'm not prepared to say without more of a development of the record that indeed it fails under intermediate scrutiny. Remember, strict scrutiny, strict in theory, fatal in fact. Intermediate, you can, there are different classifications that sometimes do pass muster. For instance, a healthcare company can say, we're not going to give pregnancy benefits anymore, just, based on that benefit, even though it only harms women. That's something that wouldn't be subject to higher scrutiny. But if a company just said, we're not going to employ women in the, C-suite executive positions, that would be kind of a rank discrimination that the court would give intermediate scrutiny to. So anyway, what happens here is both transgender minors can't get the treatment in Tennessee, and 20 other states now have similar statutes, basically from Red America. And it also, if you read the opinions carefully, it doesn't look like there's going to be a lot of action in the equal protection side of things for this court in coming years. A quick little footnote, this came up in Dobbs as well, is it may be possible, we just don't know, but an opinion by Kavanaugh and Dobbs and statements on the bench suggested it might be, you're a minor with gender dysphoria in Tennessee, maybe you can go to another state if you can afford it, to get the treatment that Tennessee forbids you from getting in Tennessee. That could be a future issue to play out. But the basic notion is the Tennessee legislature can just say, boom, no minor can get this in Tennessee. And the Supreme Court says that's just fine. That's a matter for the democratic process, the people to decide. And we perceive no discrimination of the sort that we scrutinize more closely, for example, race and religion and even sex, which we give intermediate scrutiny to. We're not doing that here, and under the lowest level, the law passes. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.